Hello, welcome to Tort Law 101. I'm Evan Manning. This is for ED 850 VB, Module 13. First are the basics of tort law. Cornell law defines tort law as an act or omission that gives rise to injury or harm to another and amounts to a civil wrong for which courts impose liability. Which for educators simply means you are the supervisor in the classroom and are the liable party if anything happens that could have civil damages. One thing important to remember for the purposes of this class is that not only is this obviously something that's pertinent to a school teacher in an enclosed classroom, but can also be applicable to a principal when they define school rules, guidelines, or policies that could have implications for civil damages later on, such as creating an unsafe rule or law in which a civil damage occurs. There are two types of tort. First is intentional tort. This is a scenario in which you personally did something, again, on purpose to cause the damages themselves to occur. Obviously, an example of this could be something as simple as you struck a student or you broke their property. However, hopefully, more common would be something called negligent tort, in which case you didn't stop or prevent something that could have been, of which damages occurred. In summary, tort law is very important. It could be the thing that not only could cost you your job, but civil damages on top. Part of the assignment was to look at some specific examples of tort law, to talk about them as a quick summary, and talk about the outcomes of them. And then there were two things also to be discussed. First is the idea of what could have been that could have prevented, or what could we do to prevent or outcomes. And secondarily, we were to look at what was the situation in which would occur in our own schools post an event of similar ideology. So the first court case I looked at was Ward versus Community Unit School District number 220. This occurred in 1993. There were two football fields that were marked by school personnel, and an accident occurred with one field player running into a spectator of the other field, and injuries were sustained. Now, the outcome of this is that the court concluded the plaintiff's facts showed that the layout of the fields were in close proximity and that supported that the actual fields themselves created an unreasonable risk of harm to the students. Again, in this scenario, it's not only what you're doing supervisionally, but even specifically for student personnel, such as whoever set up the field, whether it was you know, a custodian or whether it was someone who actually was setting the fields up that were purchased. Again, they were set up in a way in which safety wasn't a guarantee. And at that point, the school district themselves were held liable. Again, as a principal, this type of case would be uniquely important. When looking at the question, what would my school district do in something similar reactively? I do think that they would have to look at who they hired, who actually set everything up, what was the original contract that was signed with whoever set the field. Obviously, did they meet those requirements? And obviously, hoping that if it was a private contractor, some sort of a settlement could be made. Hopefully, having some liability back on the actual field creator themselves, as that's what happens at my school district. But again, in this scenario, maybe more similarly of a teacher setting up some sort of a field, via tape in a gym or with paint on a football field, it is tough if the individual teacher is the actor and is acting in good faith of the school district. Then ultimately, if they create an unsafe environment where damages occur, that liability occurs. And obviously, it's something you have to think about. I think as per the second question of what would I hope to do as an administrator in the same situation is be extremely careful of who you hire, make sure that the safety for students is paramount, and hope that hopefully resolves those situations from ever occurring in the first place. Case two was Guthrie versus Irons. This happened in Georgia in 1993. A student was beaten at a school in a hallway and died of the injuries. The parents sued the principal and the closest teacher to the attack. Again, the teacher, there's no evidence the teacher was actually present for this scenario, but they picked the teacher of whose room was closest to the attack, saying that they should have been there supervisionally. The outcome was that there was no evidence that the principal had any knowledge that the student had been threatened or was not in the area of the attack, or the principal acted willfully, maliciously, or corruptly, and the defendants were entitled to immunity from the liability themselves. When talking about reactivity of the school in this scenario, I think if this happened at my school, this would be potentially different from the first case. I think they would react very negatively because we have school policies that obviously were distinct, in which we are supposed to be in the hallways as monitors during passing periods, which is when this was alleged to occur. And in that scenario, I think if an individual teacher was not following the actual policy that was given through the guidelines, then all of a sudden there's more liability there. It's almost one of those things where ignorance is bliss. Maybe it was better not to have a rule stating that, because once it's there, then there's a rule that could have been broken. I think that would be a big issue at my school. And looking at what to do reactively, I think to try to prevent the situation best, then you have to both have the rule like my school does, trying to get as much supervision as possible in the hallways, but also obviously have the live videoing that we have in access with our safety officers, and make sure that those are being used properly, so that we obviously could have hopefully gotten in there at a faster pace before these injuries that even included death were to occur, which is obviously a really sad scenario. But it feels like with those types of injuries, hopefully someone could and or should have been there faster. But obviously in this case, the courts upheld that there was nothing specifically wrong. I would hope that that would be better in a school that I was running. Case three is Coyle versus Harper. This happened in Alabama in 1993. The scenario was that a student at Putnam Middle School was injured by another student in the classroom while the teacher was monitoring the hallway during and immediately after the class changed. The student or principal, Gail Coyle, filed a suit against the teacher and principal alleging negligent supervision. The outcome was that the court found the instructors were not liable due to the other duties of safety that were being completed. The Supreme Court of Alabama affirmed the decision of the circuit court in granting summary judgment in favor of the principal. This one's fairly interesting in that there was a specific scenario here where the teacher had sort of double duty, and that they had to be able to be two places at once. And at that point, contractually, they making sure, yes, that they were supposed to be in checking on the choir and while also being in the classroom. So at that point, as long as the teacher was trying to complete an action that had safety in it, that was okay. Again, I think for a school's reaction, it'd be very similar. We are always told, always trying to really be pressed, even for if we have to go to the bathroom as educators, that we always wait until you find someone to cover you, send an email to someone, call someone in the case of an emergency, and never put yourself in scenarios where students are left unsupervised in case something like this happens. For, again, what to do in a preventative scenario in my school, I would hope that, again, to really push and impose on the teachers that they understand the seriousness of leaving students in scenarios where things can happen with civil liability, and to make sure that they know that they are liable, in these scenarios, and maybe having a couple of these cases be shown at the beginning of the year during professional development opportunities, and be shown the importance of them could be important. I know that I think even as a teacher with ideas of wanting to be an administrator in the future, I'm sure that at times I don't, always put myself in the best situation. And although it's never backfired, is it worth it? And the answer should be no, both for the child's safety and for your own liability's sake. Case four is Morand versus the City of New York in '94. This was a scenario in which a student was waiting in the school during the school day. but not in class. So her sister was younger. She was a senior. She didn't have a last period. So she was waiting, but while her sister was still there. So she was in the school, but she did not personally have a class. She was in a fight. She got hurt. And the school was sued for improper supervision for $750,000. The outcome was that the court found the school was liable. They had an obligation to supervise all students in or not in class on their property, and they were liable for all damages. And the majority of those damages were pain and suffering. It wasn't a scenario where there was a lot of major injuries that actually cost a lot. It was a lot of pain and suffering money, which again hurts the school. But I think this one's really important. I think when talking about how my school would react, we are told all the time about whether or not we have students, don't let them, if you're an activity person, like for me with debate, don't have your kids be in there, they don't have school. Again, that it's not recess, you can't let your kids wander. When we have students who don't have periods, they are not supposed to hang out with teachers or just hang around the school. They're supposed to get off of school grounds. And again, I think this is the perfect scenario for that, because when you don't have direct supervision over a student, but sort of they wander, then no one knows they're in charge of them. The students have too much freedom, and then scenarios like this can occur. For preventative actions, one, obviously train the teachers of the situation and making sure that this doesn't happen. Two, you got to train the students. They have to know that they can't be there, that it's not acceptable. I think an option is to have a place where they could go in this very specific scenario. If you had a student who needed to wait every single day for someone, talking with administration about getting them an aiding hour, maybe even an aiding hour in the teacher's room where the sister was, so that obviously they were right there, they could leave together after, and not being put in a situation where the school's liable for this mystery ghost students that we didn't know where they existed, obviously could be good. Case 5. This is Towner versus the Board of Education of Chicago in 95. A fight between two non-school sanctioned social clubs occurred when a student was hit after the school day. He was struck with a golf club. A teacher voluntarily attempted to stop the fight. Again, this is after, so it's supposed to be voluntarily, not as a part of their actual job duties, and took the student to the hospital. The school was sued for negligence. Outcome. The court found the school was not liable. They had no obligation to supervise when there was no school event taking place, and both groups were not affiliated with the school, so the teacher also acted in good faith. As far as the reaction of my school in this scenario, again, this one might be more severe than what's happening here. They always tell us, not to have students up there, that students have to leave, that we are responsible for our areas. Again, I understand that they were non-sanctioned social clubs, but again, there's no reason that the students should need to think that they can just be hanging around the school, on the playground per se, especially at the high school level. So it doesn't make much sense. I think that you've got to figure out a scenario where the teachers and the students are better trained. There's more hard rules and a hard and fast line to get people out of there so this doesn't happen, which also combines sort of the reaction of what I would do preventatively. So reviewing, again, basics, anything where it's either an act or omission where an injury occurs that could have civil damages, that is a tort as per Cornell law. Again, educators, you're the supervisor. It's up to you to be the adult in the room, both metaphorically and in many cases literally. And because of that, you're the person who becomes responsible for these students, even if it's negligent and not something that you're physically doing on purpose. And again, that is highlighted by the intentional and unintentional, or what we call negligent scenarios of torts. So with all that being said, I know it's something that I'm going to think a lot more about when I start, not only as being a teacher, but also going into administration, something that we should all take very seriously going forward. Thank you.